My name is Grace Ross, and I'm the coordinator of the Mass Alliance Against Predatory Lending. I'm not an attorney, and this is not legal advice. We build up a lot of expertise in the Mass Alliance Against Predatory Lending because we coordinate many of the lawyers on the homeowner and tenant side of the fight against illegal foreclosures. And it's from that I share the following with you. So, one of the issues that has come up is if you have a mortgage that is in some way illegal, what does that mean and what are your rights? When you sign a mortgage, you're basically saying, if I don't pay on the promissory note, the debt itself, you can take the house. The legal contract has a lot of different elements to it that include protections of you and are supposed to include protections of the mortgagee, the party that claims to have your mortgage. That legal contract is only considered consummated by law if you had certain disclosures and it is accurate in specific ways. If a mortgage was never consummated, that means that it never legally came into existence. And there are people who have been involved in what is sometimes referred to as the nuclear option, which is if they've tried everything else they could to get a loan modification and to get reasonable good faith effort from the banks to make their mortgage affordable, they will often look back and go, oh, this mortgage, this legal document actually never came into existence because it wasn't consummated. What is required for a mortgage to be consummated? There are basically three elements. One is that whoever is written into the mortgage as the lender, by definition the lender is the party that put the money into the mortgage. If that lender is not actually the party that put the money into the mortgage, then the mortgage was never legally consummated. Fannie and Freddie, for instance, create pools of money for some of the biggest lenders and allow them essentially to write a Fannie or Freddie mortgage that was funded by Fannie and Freddie, but they do it under their own name. That is referred to as being table funded. The problem is, to my knowledge so far, no one's been able to figure out how you prove that your particular mortgage was table funded, even if you know that a particular mortgage company never used its own money. A court's going to want you to prove that that was true in your particular mortgage, and that's hard to do. The second piece of consummation is that you have a right to know who you signed your mortgage with. This means that any party to your mortgage, you had a right to have disclosed to you who they were. Many of you, and you need to be honest about this, but it's true of the vast majority of homeowners I've spoken to, will go back and look at their mortgage and find out that they know who the bank was they were talking to, and that's usually listed as the lender. But what they didn't know was that there was an additional party added to their mortgage, and you can go check this out yourself. Is there, and it's usually on the front page under paragraph C, does it say that the mortgage electronic registration systems is your mortgagee? This was the addition of an additional party to your mortgage. You were not disclosed that they were in there, and although the banks will say, well, you signed it, almost all of you had a packet this thick that you were flipped through, sign here, initial here, you never got to read anything. And it's not like they went page by page and said, oh, this is your flood insurance, this is your hazard insurance, this is your agreement that there isn't PCBs in the property, this is your agreement that we can correct your name if it's misspelled, this is your agreement, etc. There's a slew of them. And you don't even know what they are. And you're signing and initialing. So you didn't get a chance to read the mortgage from one end to the other and go, wait, what's MERS? Why is MERS in my mortgage? In fact, for those of you who were even given a separate piece of paper called a MERS disclosure, the MERS disclosure itself says that they're a computer tracking system and that your lender is going to use their name instead of the lender's name in the registry of deeds on behalf of the lender. Now the problem here is that if you had MERS in your mortgage and you go back and you look at those documents that they use to transfer a mortgage from one mortgage holder, the mortgagee, to the next one, which is called an assignment, and those are usually available in the registry of deeds. If you look at those and you had MERS in your mortgage, the first assignment's likely to say that they are transferring your mortgage from MERS to some other bank. Now, MERS doesn't legally own mortgages. But they went from that disclosure, if you were given it, saying that MERS is just a computer system and that they don't own anything, to now claiming that MERS has the power to own and transfer a mortgage. So even if they gave you the disclosure wasn't accurate for what they were going to then use MERS for. It is therefore not a legal disclosure. A disclosure has to be true, and it has to tell you what you need to know, and they can't then go off and do something different, because then it's not truthful anymore. So most folks who have MERS in their mortgage and didn't know it, and didn't know what MERS was, and didn't have information that MERS was then going to pretend to have the power to transfer a mortgage, that means there was a party in your mortgage that was not disclosed to you, and technically at least, that mortgage, if you signed it, was never consummated by you. The third characteristic of what's required to consummate a mortgage is full disclosure of all of the really relevant characteristics of the loan. And here's where this connects to the tape about predatory loans. If they didn't tell you about a key characteristic of the mortgage before you signed it, then this mortgage was never legally consummated. So, for instance, they didn't tell you there was a balloon payment at the end. They didn't tell you that it was an adjustable rate mortgage that might go up 3 percentage points, which may not seem like a lot, but if you think of your interest overall at being at 4% and it could go up to 7%, that's almost double. It's a big difference. If they didn't tell you there was a prepayment penalty, they didn't tell you, and this is the one that we think, even for folks who had technically fixed prime mortgages, they didn't tell you what the real value of the property was, right? This is during the housing bubble. Appraisers are way over appraising properties. They're not giving a realistic value. You were told, oh, this is a 80% mortgage or a 90% mortgage. You might not have understood that that was trying to tell you how much the mortgage was in comparison to the value of the property. But to have properly disclosed to you, they would have had to explain that, and they would have had to tell you the real value of the property. Since during the bubble they were overestimating in appraisals significantly, the chances are good that that loan-to-value ratio was not properly disclosed to you, and that means that probably almost all the mortgages written during that time period were never legally consummated. The fact that you got a mortgage that maybe they said was a 70% mortgage, I've had people say to me, well, I went and looked, and although the real property value, they had said it was $350,000, but I only took out a $280,000 mortgage, so the fact that it's really only worth $280,000, that doesn't, that means they're okay, right? And it's like, no, because what they were promising you was that yours was $280,000 to $350,000. It's the ratio they were promising you, not the absolute figure. So if the value, maybe didn't take you below what the value of the mortgage was, that's not what matters. What matters is that they lied to you about the ratio of how much your mortgage was and how much the property was in reality worth. We are encouraging folks, this doesn't always work, but one way that you can get your hands on something approaching what the real property value might have been at the time is to go to your city or town tax assessor's office. When they charge you your taxes, they do it based on an assessment of what they think the property is worth. The tax rate is a percentage of the value that they're charging per square foot or whatever for property that year. So they have to include in that bill what they appraised the property for. So if you go to your tax assessor's office for the year or 2 years or even 3 years before you got your mortgage, the one that they're trying to foreclose on, that will give you a more realistic sense of what the property values were. And although in some parts of Massachusetts there wasn't that much of a housing bubble, in the vast majority of Massachusetts there was a very significant housing bubble, and you may be able to catch it with the free documentation from your tax assessor's office. And we strongly encourage you to do that. Fannie and Freddie, of course, have the most expensive research in the world, and they can go back and look to see what the property values were supposedly at that time. We don't have access to that. So anyway, that's what it takes to consummate a mortgage, and the vast majorities of these were probably never legally consummated, and that should give you an upper hand. If not in court, you can use it to push what you get for a loan modification.